Hello, and thank you for joining us today for our webinar with Ward PLLC, Back to Business, but not business as usual. My name is Lizzie. I am a Senior Account Manager for Locology, and I will be your host for today's event. A few housekeeping items before we begin. This webinar is being recorded and will be circulated to all attendees with the presentation within 24 hours of the broadcast. Questions will be answered during the Q&A session at the end. You can, however, ask questions at any time during the broadcast by using the question window in your control panel. I will now go ahead and pass it over to our senior analyst, Charles Laughlin, who will present our speaker for today.
Thanks, Lizzie. Hello, everyone, and thank you for joining today. I know I'm excited to learn about data strategy during and after COVID because it's a topic I'm always fascinated by and always looking to learn more about. Really excited to have James with us today. I'll give a little intro to James, and then I'll hand it over to him and let him get started. James is a privacy lawyer and data strategist, and he's based at the University of Oxford Internet Institute. His studies focus on the interaction between legal structures, connected technologies, and human and autonomy. James he's the founder and managing partner of Ward PLLC, and it's a law firm and a data strategy consultancy. I'm not going to go through this whole bio because it's lengthy and impressive, but I will say that he is the author of Data Leverage, Unlocking the Surprising Growth Potential of Data Partnerships. It's a book many of you may have read. It's a bestseller based on focusing on data partnerships, privacy, and data strategy. James is a frequently quoted expert on privacy matters. He's been in publications ranging from the New York Times to Forbes to the International Business Times. He's a certified fellow in information privacy, and he holds certifications in European and United States data security and privacy law and privacy program management. And previously, James was a high-stakes litigator, to use his terms, focusing on intellectual property, financial services, and consumer class actions. And you're not a black belt in jiu-jitsu, right? Or a classical pianist, but otherwise, you have a very impressive resume, and I'm very excited to hear what you have to say today. I'm going to hand it over to you, James.
Thanks very much. No black belt. I'm pretty good at Sudoku, but that's about as close as I get.
You could be a black belt in Sudoku. Yeah.
I can. Yeah. No, I do the mediums, and I feel really good about myself. Well, it's great to be here. Thank you, Charles, and thanks for everybody who's joining us today. It is certainly an interesting time to be thinking about how to have a long-term strategy when everything that we're going through and every day seems like we can just really barely get by focusing on what's right in front of us. And that's natural, both in your personal life and as a business. Thinking about how to get through something completely unprecedented really is a natural impulse. But I think when we're talking about the really substantial shifts and dynamics in the market right now, particularly the move from brick and mortar to e-com, the shift in business model and data intake by local businesses and the businesses that support and provide for them, and just the overall transformation of an economy that's going to contract and expand in line with what's happening, kind of in the real world, so to speak. It's crucial to have a forward-looking strategy. So a reopened business isn't necessarily the business that it was before the shutdown, and that's why we need to have a strategy that looks forward to new ways of operating and new ways of forging success and new partnerships. But that means really being aware of where we are and where we're going. So as mentioned. Part of the work that I do is in data strategy. Part of it is in the compliance and legal space. And one thing that I hear when talking about the strategy of data when it comes to the laws that apply is something along the lines of, well, GDPR is a big deal, I get it, and CCPA is a big deal, but we don't really do much in Europe, and we don't have a ton of cash right now, so we'll deal with it, maybe next quarter, and then it's the next quarter. It's always, N+2 is the time to deal with it. And we won't say who actually said that. We know it's Phil in accounting, but we don't actually need to name him. And then a similar story from other people who feel the same way. And then we hear also in a similar way that for people who have some familiarity with privacy law, that it's sectoral. We don't need to be worried about privacy or data strategy or what's done with data, because we're not a covered entity under HIPAA and we're not a bank dealing with GLBA. So as long as we stay out of that alphabet soup, we don't need to worry about it, even though we've now moved to e-commerce as a massive shift from the way that we were operating before. That's also Phil from accounting, but I mean, he's all over the place, but he's not alone in thinking that. The problem with both of these thought processes is that they're a little bit right. There's some truth to the fact that privacy law has been sectoral for a long time, and that, you know, if you don't have a business presence in Europe, GDPR doesn't apply to you if you're not marketing or selling there. But it's mostly wrong. This approach is mostly wrong for two key reasons. Even though GDPR doesn't apply to American businesses that don't market and sell in Europe, it has changed the way that people conceptualize data and the way they understand the relationship between data, commerce, and individual privacy. And that shift in understanding isn't just a European phenomenon, it's around the world. GDPR has been the model for laws everywhere from Taiwan to Brazil to Mexico, and indeed in the United States. So thinking about privacy is just the way that we've in the US thought about it for a long time. Like, well, there's PII in this file. That's the wrong way to think about it. And it's because GDPR has created a new sense of awareness from consumers that, you know, maybe you'd think that there would be new lawsuits and new claims arising. But not really. It hasn't really happened. What there has been is a sense that because I'm not getting massive amounts of data subject access requests, that I'm fine, that nothing has really changed. But the ground is changing underneath us, and as the shifts in the economy take place now, and as we try to grapple with the after effects of the COVID, we're going to need to be aware of what those shifts in privacy are. Well, where are those shifts taking place? Well, largely in the States here in the US. It's true that there are privacy laws elsewhere, but there are plenty of privacy laws in America that are very important and have a meaningful effect on your business. Obviously, CCPA is kind of the big dog, and everybody's been talking about it for a year and a half, and just the week before last, it became effective. But it is not the only story. And in fact, there is an emerging consensus among the states that even if you don't have an agreement about what the privacy law needs to look like, you need a privacy law. And in the absence of federal law, which we'll come back to, states are really carving out kind of a bifurcated system. You have this sort of regulation, regulatory authority, compliance-driven regime in places like Washington, Massachusetts, Illinois, California. And then you have a more market incentive-driven approach, which has safe harbors and guarantees of non-liability for meeting certain standards in places like Ohio and Texas. And the question is, which one of these is going to prevail? But both of these facts together, the fact that GDPR has reframed the way everyone thinks about privacy, not just Europeans, and the fact that there's a movement in the US states to change the way we approach data and privacy, it really gives the lie to the quotes that we had at the beginning. So let's dive into the CCPA. It's a total mess. It is just a complete mess. It's as complicated as you've heard, and now it's on the books. The enforcement actions have already started. Literally on July 1st, the first letters from the Attorney General's office went out. But it is not a very easy to understand statute. And that's because it was rushed through in 72 hours by the California Assembly, the state legislature in California. Because originally CCPA was a ballot referendum. I don't know if you've ever seen those stickers that say, this building or this product or these potato chips contain chemicals which are known to the state of California to cause cancer. Well, that was a ballot initiative. That was Prop 65. And what happens when you have a ballot initiative that passes it's immediately the law as written, and you have to live with it. But if you have a statute that's on the books, you can amend it in different ways, and you have the possibility of kind of dragging out the pre-enforcement period. So the California legislature struck a deal with the principal drafter of CCPA as a referendum, a guy named Alistair McTaggart, and said, all right, we'll put this on the books legislatively, you withdraw the referendum, everyone will be happy. And he agreed, and in 72 hours, they basically hit Control-C, Control-V, and then made some key edits. And then they passed it unanimously without reading it. And that's why there are definitions of personal data in the CCPA that nobody really understands. Like, how do you identify a household under CCPA? What does it mean to restrict the forward transfer of data? Is it a sale or is it not a sale? None of these things were answered. We still don't know really now, even though the law is in place. Guidance that we've gotten from the Attorney General isn't clear. The likelihood of it being enforced robustly by the Attorney General isn't clear, because he's already said he can probably do 1 or 2 cases a year. It's a right old mess, but we'll see why it's important as we go on, because California, as the leader in the field, set a standard, which means, of course, other states want them, we're coming in, we can't be behind the Californians. So some other states like Nevada, Washington, Massachusetts, Illinois, have either already enacted or are in the process of bringing out new laws that go even further than CCPA. These include disclosure obligations, comprehensive rights to access, deletion, and in some cases data mobility, and the big one, private causes of action that aren't tied to damages. So what does that mean? Well, if in the move from brick and mortar to e-com, or in a SaaS provision platform to a local client, we're collecting data but not storing it properly. If the data is improperly accessed or sold or shared with a third party without the proper consents, every time that occurs, the individual whose data it is has the right to a $750 penalty per incident. So in context, in Equifax, and obviously we hope that most businesses are being a little bit more careful than Equifax was, that would have been in Massachusetts, where where one of these statutory damages provisions in place, we'd be talking about almost a little bit more than $2 billion in statutory damages, not even tied to any underlying harm. There wasn't $2 billion worth of harm that we know of. That's just what would have been right off the top. So these laws are a really big deal, and they have substantial effects. And even if we're not thinking about them now, because we're really focused on COVID response, we need to be thinking about them right now, because in the haste to get something done, or in the haste to make a move, if a law has a statutory damage provision, you're not going to be able to say in court, well, Judge, I think we should throw out the case because it was COVID and things were sloppy and they were messy. The judge is going to say, right, but it's a statutory penalty. There's nothing I can do about it. So care now will save you a lot of harm later. Washington has taken an approach that's just like Massachusetts. California has gone even further than itself. McTaggart, who saw the changes that were made to CCPA last year, was so unhappy that he wrote a new initiative, the California Privacy Rights Act, which is even more robust than CCPA, and in fact is more aggressive even than GDPR. There's going to be a California privacy rights regulator. There's going to be all kinds of statutory penalties. There's going to be huge restrictions on data use cases. It is a huge mess. And if you think that it's easier to deal with Europe because you can just have the data that the Europeans are creating sent over to the US through the Privacy Shield framework, I have bad news for you. 6 hours ago, the Court of Justice of the European Union said, because there is no uniform law of privacy in the United States, and because all kinds of intelligence agencies can see personal data pretty much whenever they want, the existing framework for the simplified and easy transfer of data from Europe to the United States, the Privacy Shield framework, is no longer valid. So if you're a business doing business in Europe with European clients and you were using Privacy Shield, now all of a sudden you're not using Privacy Shield, which means you have to completely rethink the way that you're approaching data. And I use this as an object lesson, because we're in the midst of a crisis, we're in the midst of a pandemic, and yet the law goes on. The CJEU ruling today doesn't take any account of what's going on in the world around. It's simply a question of what the law says. So when you see this comprehensive and very complicated patchwork of laws in the United States that's responsive to GDPR, but also is driven by the needs and the exigencies within each individual state, you recognize that COVID is not an excuse for what's going on, for making a mistake in how you manage data, or for not thinking clearly about the strategy that you want to employ when you're using data. So is that the only approach that states take? No, there is a market model that's sort of a counterpart to the GDPR model. It's a balance between securing a limited number of categories of sensitive data, but really it's about creating incentives for not falling below minimum thresholds. Are you encrypting data at rest? Great, that's a safe harbor. Are you having a third party certify your activities? Great, that's another safe harbor. Of course, being certified to the Privacy Shield standard for some of these states was enough to get you into a safe harbor, but now that Privacy Shield is gone, that's gone too. It is possible to have a market-driven approach, but it's not really taking off. Ohio and Texas have it, but it hasn't been adopted many other places. And even if it did, it's very rare to run to a business that's managing and dealing with a lot of data that's just in Ohio or just in Texas, or even if it is, that doesn't eventually want to be selling in California, the 11th largest economy in the world. So that's that returning to that concept of just thinking about now, not serving us well. So what do? How do we come up with a structure, a framework, or a roadmap for dealing with our current crisis and strategizing about future success at the same time? It's not easy, because there are a lot of different needs that need to be balanced when we're making those analyses. And what we think is that having a really unifying principle at the center of the way that you deploy data, that you take in data and use it, is the way to go. And the consensus in Europe and the emerging consensus in the United States is that the value criterion that you should have, the real central core tenet of your approach to information, needs to be privacy by design. And PBD is a concept that's been around for more than 40 years. And what it really means is that when you deal with data, when you're dealing with personal data, when we're not talking about transactional data, but personal data, anything that identifies an individual or could identify an individual. And that's everything from a business telephone number to a Facebook profile picture. Anytime you deal with that information, how you use it needs to have privacy built into the structures that govern the way that you use it. There are limitations on who can access information. There are limitations on how you approach the third-party access to the information. You're focusing on what needs to be done to protect the person who created that data. And when we're talking about personal data, we have to remember there's always a real human behind that information. And that's what drives much of the law behind privacy. So as we sort of test out ideas about what to do with data and changes in our models and take them to from that sort of theoretical place to commercial deployment, we have to understand that there's risks. Yes, new ideas about what to do and new ideas to respond to a changing market that's essential. You have to do it. You need to respond. You need to have a flexible and robust approach to devising new policies, but there's risk there. And there's also a need to understand that anytime we're dealing with a new strategy for business, we're really talking about data partnerships. How are we going to get the new information in? Who are the local businesses that are my constituency, are my clients, are my partners? And who are my competitors that can maybe help me identify where I can improve? What are the groups within my business that can partner to provide new insights and movement forward? Those data partnerships and the commitment to privacy by design together need structure. You need to identify those risks as you move to to commercializing new strategies, but you also need to think about how best to drive growth based on these changes. And in the book that that Charles mentioned at the beginning, our data leverage, we call the approach that we've devised the Data Smart method. And that's my shameless plug for the book, but we like it and we spent some time thinking about it. So it seems like the right place to bring it up. So what is the Data Smart method? It's a 4-step process, and it's a 4-step process that you can deploy anytime you're thinking about use cases for data, how you want to create new partnerships, the creation of a new derivative or synthetic data product. Anytime you're talking about data and the use of information, internally, externally, whatever, you can use this method because it scales, it's self-reinforcing, and it gives you the framework and guidance necessary to be able to really implement best practices while having a roadmap for the organic development of new ideas within your company. And these 4 steps, as we lay them out here, really do kind of flow into one another. Identify the data that you have, both from the intrinsic data and the extrinsic data you make and data you bring in. Determine what the value proposition of a proposed use case or product or new activity is, but also the risk. Create legal and strategic structures around that data or around the use case that will give you not just sort of we'll make a data lake and we'll bring in a lot of data and then we'll do something with it. No, you need to have a real framework to figure out how to put the value in that information to work and then protect it as you go forward. Secure the data, secure its access, and secure the rights of the people who created that data. Identify, value, structure, protect. This is the framework that we recommend and that we use with clients every day. We start with identify because it's really important to look at the information that you have, the information that you're producing, like what is the kind of the exhaust fumes of running my business? What data am I getting from the local businesses that I work with or that are a key part of my business proposition? And then extrinsic data, what am I getting? Am I buying data from Dun & Bradstreet to sort of fill in and append to my information? Am I buying information about potential clients from other third parties? Do I get valuation data from Duff & Phelps? Whatever you're doing, figure out what all of these data sets are. And I guarantee you when you do this exercise, and I suggest that you map it, but when you do this exercise, you're going to sit down and say, someone will say, I don't think, we have a couple of data, we have this data or that data, but that's basically it. And you'll write down 3 things and be like, oh, this is it. But it's never that simple. The map that you're looking at here with some minor changes represents an actual mapping exercise that we did. This was 3 minutes into our mapping exercise during the identify stage. And this was 7 minutes in. This is what happens when you do this analysis, and this is not even the entire map, this is just the extrinsic data sets. What happens is you'll find very rapidly that the amount of information you're pulling in, and just as importantly, the amount of information that's going out is astonishing. So why we suggest doing this is not only does it give you the ability to recognize what information you already have and potentially how to create new value out of it, it also helps you really recognize what you didn't know that you had that's maybe risky, or that you didn't know that you have that you don't want anymore, relationships that aren't really valuable anymore. This is how you accomplish those things. And at the same time, if a regulator comes to you, or an auditor, or God forbid, a lawsuit, when they come to you and say, what information did you have and when did you have it, you don't do the sort of shoulder shrug, I don't know. You want to be able to say, yeah, we've mapped our information, we understand what we have, and here's how we've framed our our approach to data through assembling this map. It takes time. This identify stage it's not a fast process, because if you do it well, the data mapping, the heat map, the data flows, all of that stuff, essentially what you're really doing is building a data architecture. You're going to see where things need to be shorn up. You're going to see where things need a little bit more support, both in terms of how you're storing the data or who has access to it. It takes time, but it is unquestionably worth it. But it requires leadership. You need leadership at the company to say, yeah, this is a valuable and important thing. And getting that support at the early stages is difficult. It's one of the things that we work when we start with clients. It's one of the very first things we do. And it always pays dividends to have champions in leadership recognize the value of data, because even if you don't know that you're a data company, you're a data company. All right, so you've done the identify stage. Why would you value the information now as opposed to later? What's the purpose of doing valuation? Shouldn't that happen at the end? And it is kind of counterintuitive, but our view is, why go through the process of structuring and protecting a data asset or creating a new data partnership with a client or a customer when you haven't thought about the risk and cost, right? So one of the things that one of the exercises that we went through with a client was, they had a fair number of, they had something like 700 different individual attributes to their clients. So like, we have the most robust and detailed data set about our customers. We know everything. We've got the best predictive models, blah, blah, blah. Okay, great. And of those 700 data sets, we said, all right, in the last 18 months, how many of them have you actually used? And the answer was around 80. I said, okay, all right. Well, of those 80, how many have generated 1 cent of revenue for you in terms of the deployment of resources or the creation of new clients? And the answer was about 30. And they were spending more than $500,000 a year on some of these data assets and data sets that provided them nothing. But they were holding on to all of this information, which creates regulatory risk, because you can't be in trouble with the regulators for data that you don't have. But if you have data you don't need and don't use, you're going to be in even more trouble than you'd be otherwise. It creates opportunity costs, because there's other partners that you could have been buying better and more useful data from. And it creates actual costs in terms of housing all of that information, structuring it, rigging it, paying to house it on Azure, the ecological cost of storing this data. There's a lot of things that go into keeping data. And so that's why we say value early, because you can do the risk reward ratio and see kind of roughly which of these buckets you think a data set falls into. Is it worth nothing to pay for, but will people share? Will you create a data co-op out of it? Great, put it in the $0 bucket. Is it the be all end all of your company's existence, and this is the only way that you can go forward, but it's going to be a golden goose? Great, put it in the unique or critical bucket. These buckets are really more directional. They're about giving you an idea of how valuable data is, but they're not perfect. It's not like these are the 4 sets and that's the way that it's supposed to go. It's really about thinking through the valuation of the data set that you have, and also recognizing that at times the risk will outweigh the reward. Think of it this way: if you have 1,000 customers and you need to validate their identity to perform a transaction, and you have their name and address, and you also have their social security number, and it costs you nothing to get all 3 of those things, great. They all have roughly the same value to you, because keeping the name and address or keeping the social security number doesn't cost you anything, and it actually tells you exactly who the person is. Now think about the risk. The name and address, well, some risk there, but not potentially high. Social security numbers, we're looking at potentially ruinous costs if that information gets out of the company, and it's not necessary. You don't need to hold that information. So doing the risk and reward valuation early helps keep you from making decisions that later on you won't want to have to answer questions about at a deposition. So now that we've done the identify and value stages, we're going to structure these relationships. And what does that mean? Well, a lot of it is about how you connect your data with other data sets, and whether that's between 2 groups within the company, a data partnership with one of your customers or clients, getting information from them to refine your own services, then maybe help them see how to improve their own. Any way that you want to frame the structuring of the data and structuring of the partnerships, there are internal and external, and then legal, technical, and strategic components that you need to bear in mind. But again, this is building an architecture. This is building the framework for how your strategy, especially strategies for change in a changing market, need to be done. So thinking about structure rather than just a product, thinking about the strategic goal of bringing in a new data set or providing a new data asset or portal to data inventory to a customer or a client, that's much more important and much more valuable than just saying, yeah, we're going to get new information. And that sort of data gluttony becomes a habit that's important to break. You can create structures in any number of ways, and we actually go through a lot of this in the book and talk about which one of these are most common, which one of them are the most valuable. But you'll find as you go through this exercise, it's kind of an organic process, and you'll see who it makes sense to partner with and how to manage that partnership. All that being said, innovator, where you partner with someone who has a new idea that you want to sort of move ahead off of. Mutually beneficial and channel partnerships, which is essentially how you promote yourself to new clients and new customers through data relationships. They're the most common, and they're the ones that, for instance, we see most frequently when we're designing data partnership agreements or data licensing agreements. But don't forget that you need to have both data architecture, data, in many cases, data science, and legal strategy put together. Because if you're not thinking carefully about the use cases, like are you limiting the derivative rights to the data sets that you're now sharing? Like if you're not, then you're potentially losing out on the opportunity to have a recurring value and recurring revenue generating tool. So that's why you need to have the legal strategy in mind as well. The legal piece really does dovetail directly with protecting data. This is where PBD is most clearly present, but not exclusively at all. And this is sort of archetypically when we're talking about privacy and data strategy, what most people are thinking about. They're thinking about, well, is there a data protection officer? Are you conducting audits? Do you have somebody coming into red team? What are you doing? Do you have role-based access controls? This is the sort of standard regulatory compliance. The FTC calls it start with security. This stuff is really important, even if it seems a little bit tired now. We all know, yes, change your passwords, but it's a lot more than that. And creating valuable data assets really does require that you have a long-term approach to protecting it. Particularly now, I think as the monitoring and surveillance and tracking in response to COVID and response to changes in the marketplace as a result of COVID are going to make people very wary and concerned, or at least aware of the fact that their data is being used in new ways. So thinking now about incorporating privacy into what you're doing with these new data sets is really, really important. And this is when you have to be aware of, you're in the contracts that you're signing, what are your partners doing with the data that you're generating? What do when you sign an agreement with your customer and they're providing you new data, for instance, that's going to help you create market insights, does your customer, does the local business have the rights to bring that data to you? If they're a California company, are they bringing you data that's been subject to a don't sell my data request by a California resident? These are the things that you really have to be aware of, and sometimes it's hard to know the right question to ask, which is why it's really important to talk to someone who knows the rules and who can give you guidance. So I don't want it to seem like there's one size fits all. This is going to be the solution to our data problems. There's no such thing as a perfect data strategy for protection and perfect privacy rules. It's about being directionally correct. It's about demonstrating your commitment to making the right choices and to showing that PBD is a part of what you do. And if you demonstrate that through, iterating on your own practices, doing self-critical analyses at the end of the year, conducting audits, that's how you create sort of the documented proof that you're serious about privacy and serious about protecting data, and that will see you through many a difficult scenario. So overall, I think the most important lessons is as you're thinking about strategy for data and data use cases in the midst of COVID, you really need to be focused on privacy by design. It's necessary to incorporate privacy, but also it's an advantage. One thing that we talk a lot about is privacy as brand. representing to, to your customers and clients, and then to their customers and clients, that the data that's being collected, the data that's being pulled in, it exists in kind of a safe ecosystem. That there's trust, and that the information that's shared is only shared for the purposes for which it was given. That means something, and it increasingly means something. People are becoming much more aware of their data rights and the need for privacy, as we said at the outset. We think that the best way to implement privacy by design and to create a rational, thoughtful approach to dealing with data is to follow that data smart method. Identify, value, structure, protect. What are the data assets? What are they worth? How do we structure them? How do we protect them? And it works for everything from creating a new partnership to creating a product. But you have to have a set policy and a set approach if you want to be able to have consistent results. And that being said, those results very often come in the form of partnerships. That's what the book is really about. It's unlocking the value of data partnerships. They drive growth. Creating data partnerships is what drives growth. I mean, there's that quote about, the biggest hotel company in the world, or at least it was, Airbnb, doesn't own a hotel. The biggest transportation system in the world, transportation app in the world, Uber, doesn't own a car. These are all about sharing data assets. Uber is really an overlay of traffic data, GPS location, weather, and time. Those are the data sets, but by pulling them in an innovative way, Uber was able to create something extraordinarily valuable. You can do that both internally and externally, finding partners in another part of the business or finding partners in another part of the country. It doesn't matter. Think about the innovative ways to craft new partnerships, to drive your own value and to deliver new value to your customers and clients. And if you do that, I think you will be able to move beyond kind of the, just getting through today in a way that's sustainable and that will give you the opportunities for growth during and after COVID. And that's the extent of my presentation. I'm looking forward to some questions.
Great, James. Thank you. That was really, really good. And we have a few questions, but for starters, maybe it would be great if you could just expand a little bit on today's ruling out of the EU and kind of how people need, I mean, you sort of talked about it a little bit, but maybe you could expand a little bit on how we should interpret that and how serious it is.
Yeah, so it's called Schrems II, named after the guy who brought the lawsuit. He's the same guy who brought Schrems I against Facebook, and his argument was, I think he was a grad student at Trinity in Dublin, and he did not like the fact that Facebook was sharing personal data with the intelligence services in the U.S. And Facebook said, what are you talking about? But of course, everybody knows what's going on. And so the idea was in 2015, when Schrems I came out, at the time we had a data transfer mechanism from the European Union to the US called Safe Harbor. And the Court of Justice of the European Union said, no, there's no way to adequately protect data from personal data from Europe and the United States. It could be given at any time to government authorities. And so Safe Harbor is invalidated. And so we spent a couple months negotiating, and we said, all right, so this time we really mean it. We really promise that we're going to protect European personal data. And we have a new system that we're going to call Privacy Shield, which sounds like one of those sheets that you put on top of your cell phone so that people can't see what's being written on it. It's just a terrible name. And essentially, it was no different at all than Safe Harbor. And unsurprisingly, because the nature of intelligence and the nature of data gathering in the United States has not changed in 5 years, the court today was like, well, this is the same thing. There's absolutely no difference here. So what does that mean? Well, if you were certified to Privacy Shield, then you're not anymore. And that means that you need to have a different way of getting data from the European Union to the United States. The good news is that the second part of the Schrems ruling, upheld the ability to use what are called standard contractual clauses. And the SCCs are an addendum that you put at the end of a contract that says, here's what we do to protect data. We promise that we're not going to do anything untoward with it. Wink, wink, we're not going to give it to the NSA. We have all kinds of safeguards. Now, if it sounds to you like that's a promise from an American company that they're going to comply with European standards of data protection, that's exactly what it is. And so why would that be okay, but Privacy Shield, which is basically the same thing, not be okay? And the answer is it's politics. It's turtles all the way down, right? Because the European intelligence agencies do all the same stuff. But what you need to do is you need to find out, you need to figure out if you have to add standard contractual clauses to the contracts that you have to get data out of the European Union. If that doesn't work, you have to find another basis for transferring it out. You can, potentially get consent, but consent is a very weak basis for getting data from the European Union. And then, wait 6 to 9 months, and they'll probably have negotiated something new. There was Safe Harbor, then there's Privacy Shield, and maybe it'll be like Data Protect or something like that. Who knows? But something will happen.
I'm sure they'll brand it brilliantly. Okay, so we have a couple of questions from the audience, kind of related to sort of scale thresholds, I guess, for lack of a better term. I'll sort of condense these a little bit, but the first one is sort of specifically for like churches or faith-based organizations. Best path forward, given many are small, not technically savvy, raise funds through donations and use a plethora of volunteers. I guess there's that question, and then the other one, sort of related. Do these laws have thresholds related to the quantity of data maintained by the organization? So both sort of relate to our small, non-tech savvy organizations dealing with relatively small amounts of data, in some way exempt from any of these laws. Yeah,
so that's a very good question. So the answer is yes, they do, if you're talking about American businesses. So CCPA has, basically there's 3 standards for CCPA applying. So you have to be a for-profit business, so churches are out, and you need to either have gross revenues of greater than 25 mil. You need to buy or sell or use more than 50,000 data from like 50,000 people or devices or households. So, very weird. If one household has 12 devices and there's 6 people in it, does that
which is not uncommon?
Right. So if there's one household, 6 people, 12 devices, is that 19 altogether, or is it just one? It's not clear. But anyway, just assume that. Or if you're basically a data broker, if it's 50% of your rev comes from selling personal data. So churches and nonprofits largely don't have to worry about this because the concerns, basically they're out. They're not a part of that. In Europe, it's not quite as simple as that. If you're in Europe, if you're based in Europe, then it applies, but except it doesn't, because sometimes religious organizations have exemptions for internal uses or the household use exemption. Very confusing. So the answer is, I'm going to give you the answer that every lawyer always gives, that is the reason why people hate lawyers. It depends.
On the one hand,
on the one hand, but largely no. I think, does that mean that churches or faith-based organizations can kind of do whatever they want with data? Oh my goodness, no. Good data hygiene and trusted environments is an essential part of maintaining security. And if you don't maintain control of and restrictions on the use of data, even if you're not subject to CCPA, you can still be sued if you were negligent in how you're managing data. So, it's not inconceivable that there would be a situation where data was mismanaged by, let's say by your local church, not subject to CCPA, but still subject to, a general claim for negligence.
Okay. I had a question that kind of pops up when you mentioned the penalties per incident, and an incident is sort of like one data subject, right? And how ruinous those potentially are for a company like Equifax, the example you used. And the question that came to mind for me is, that sounds like a theoretical sort of existential threat to a business of that size. Do you feel that there's going to be enough sort of regulatory fortitude or fortitude on the part of enforcement to really pull that trigger? Or how do you see that? How tough do you think enforcement's really going to be, I guess is the question.
Yeah, so I think it depends.
On the one hand.
Yeah, I can't believe that people actually pay to hear that from lawyers. The answer is it is highly unlikely in my mind that a mom and pop that accidentally deletes data from a customer is going to have guys in blue jackets banging on the door.
Sure.
It is highly likely in my mind that someone who is already under a consent order for misuse of data will face massive fines if they continue to use data in the same way. I know that because that's what happens to Facebook. Facebook it's under consent orders from the FTC, and then the FTC says, I thought I told you about this, and Facebook continues to do what it does. So if you're not Facebook, what should you do?
Yeah. You
need to be thoughtful about the way that you use data. Never, ever, ever lie about what you're doing with data or how you do it. Because then that becomes, there's claims for fraud there, but there's also False and Deceptive Trade Practices Acts. So you either get the Federal Trade Commission after you, or you get an unfair competition law claim in California, or a FDUCPA claim in Florida. Those are bad news. You never want to be in one of those cases. And document everything that you're doing with your data. Really have a well formulated, clearly enunciated policy with data protection, data uses, and what you're doing. And follow that. Like, don't just write the policy, actually do that. Audit yourself, see if you're actually following through on your requirements. If you do that, are you going to be protected from all liability? Of course not. Are you going to be able to make with a straight face, make a claim to a regulator, look, we were really trying, something happened, or someone did something they weren't authorized to do? Yeah, and that matters. The FTC is not looking to play gotcha in these situations. They're the primary privacy regulator in the United States, for want of a better term. And the European regulators aren't either. This is not a revenue generating exercise for a lot of them. So they want businesses to make the right decisions, and they want businesses to show that they're trying. But to the extent that on the scale of 1 to 10, your wince factor when you tell your grandma what you're doing with data, if she like squints at you and says, oh, I don't know, rethink it. Those smell tests are really valuable, and they keep you honest.
Okay. Last question is, this patchwork of U.S. regulation that we have now. What are your sense of the prospects that this will be tied up into a single federal law, and will that happen? And and if it will, when, in your view? And if not, what happens? Is it just going to be a continuation of what we have? Kind of talk about that a little bit.
I think that people have been saying for years, oh, there's going to be a new federal privacy law, or rather a federal privacy law, for years, and I haven't bought it. I don't think it's been accurate. And with the benefit of hindsight, I can say that I was right. But I mean, if you look at our blogs going back, we've said that it's unlikely. I think there is a chance, though, that 2021 is the year that it happens. A lot of it's going to depend on how the election shakes out. But there's an emerging group in the Senate that crosses the parties that's generally looking to implement some actual privacy rights on the federal level. But I can't say that this is me saying that I think the chances of it succeeding and being something like GDPR have gone from 0 to 10%. I don't
still
think
unlikely.
There may be a federal law and there may be some rights, but I think next year there's a non-zero chance. But I don't think we're likely to see something really comprehensive. As the years go by, I think it will become more of a priority. But there's going to be a lot of pressure to prevent that from happening.
Yeah. Okay. Yeah, I could go. I guess quick follow-up there is, if there's a federal law that's less stringent than CCPA, does that, just this is probably just a basic con law sort of question, but does the standard default to the lesser federal regulation, or can CCPA still be a tougher rule?
Yeah, so it depends on how they write the federal law. Preemption is a very tricky thing. They can write the law that says, for all states, this is the floor. This is this is the minimum, and you can go beyond that. And there are some federal laws that are like that. And then there are federal laws that completely occupy the field and say no one is allowed to regulate data except us, and what we say is the final word. That's what's done in pharma cases. That's probably not going to happen. But I think it's going to depend on who's writing the bill and what the majority looks like in the Senate, because I think it'll get through the House. But there is a possibility that CCPA could effectively be wiped out. And frankly, I think CCPA is probably gone anyway. I think CPRA, it's on the ballot now. It was just approved for the ballot, and I think it probably will pass. So CCPA is not long for this world. It'll be out of here by 2022. But will the federal law upend it? I mean, it depends on what happens in November.
Yep, that's true about a lot of things. All right, James, it's been a very insightful and interesting almost hour. And we hope everyone who is out there enjoyed this. And Lizzie, do I hand it back to you for anything?
Yep, perfect. So thank you guys both too, and thank you for putting the presentation together, James. It was very insightful and educational, so thank you. And just a few more items from Locology before we end today's webinar. You will be able to view today's broadcast along with previous webinars on our website, locology.com. Just navigate to Research and Resources and drop down to Webinars. Thank you so much for joining us today. Please be sure to visit locology.com and subscribe for updates to be the first to know about future webinars. I hope everyone has a great day.